Labor Law of Cambodia, 1997. Child labor and women labor. Section 8, Child labor, women labor. A. Joint provision, Article 172. All employers and managers of establishments in which child laborers or apprentices less than 18 years of age or women work, must watch over their good behavior and maintain their decency before the public. All form of sexual violation, harassment, is strictly forbidden. Article 173. A Prakas of the Ministry in charge of labor shall determine the different types of work that are hazardous or too strenuous and that shall be prohibited to children aged less than 18 years. The Prakas shall also establish the special conditions under which minors can be employed in insalubrious or hazardous establishments where the staff is exposed to arrangements harmful to their health. Article 174. Minors less than 18 years old cannot be employed in underground mines or quarries. The Prakas of the Ministry in charge of labor shall determine the special conditions of work and apprenticeship for minors aged from 16 to less than 18 years for underground work. Article 175. Children, employees, laborers, or apprentices aged less than 18 years cannot be employed to perform night work in any enterprise covered in Article 1 of this law. The Prakas of the Ministry in charge of labor shall determine the conditions under which special dispensation can be allowed for teenagers over 16 years of age. A. For work performed in the industries listed below, which, because of their nature, must operate continuously day and night. Iron and steel factories, glass factories, paper factories, sugar factories, gold ore refineries. B. For an inevitable case that, when an act of God obstructs the normal operations of the establishment. Article 176. The nighttime break for children of either sex must be a minimum of 11 consecutive hours. B. Child labor. Article 177. 1. The allowable minimum age for wage employment is set at 15 years. 2. The minimum allowable age for any kind of employment or work, which, by its nature, could be hazardous to the health, the safety, or the morality of an adolescent, is 18 years. The types of employment or work covered by this paragraph are determined by a Prakas, ministerial order, of the Ministry in charge of labor, in consultation with the Labor Advisory Committee. 3. Regardless of the provisions of paragraph 2 above, the Ministry in charge of labor can, after having consulted with the Labor Advisory Committee, authorize the generation of occupation or employment for adolescents aged 15 years and over on the condition that their health, safety, or morality is fully guaranteed and that they can receive, in the corresponding area of activity, specific and adequate instruction or vocational training. 4. Regardless of the provisions of paragraph 1 above, children from 12 to 15 years of age can be hired to do light work provided that a. The work is not hazardous to their health or mental and physical development. B. The work will not affect their regular school attendance. Their participation in guidance programs or vocational training approved by a competent authority. 5. Prakas issued by the Ministry in charge of labor in consultation with the Labor Advisory Committee will determine the types of employment and establish the working conditions, particularly the maximum number of hours of work authorized as per paragraph 4 above. 6. After having consulted with the Labor Advisory Committee, the Ministry in charge of labor can wholly or partially exclude certain categories of occupation or employment from having to implement this article if the implementation of this article for these types of occupation or employment creates considerable difficulties. Article 178. The labor inspector can request a physician, who is in public service, to examine children less than 18 years of age employed in an enterprise in order to establish that their jobs are not beyond their physical capabilities. If this is the case, the labor inspector is empowered to demand that their job be changed or that they be let out of the establishment upon the advice or examination of the physician, if their parents so protest. Article 179. All employers must keep a register of children aged less than 18 years old. whom they employ, indicating their date of birth. This register must be submitted to the labor inspector for visa, approval, observation, and warning. Article 180, in orphanages and charitable institutions in which primary education is given. Occupational or vocational training for children less than 14 years old must not exceed 3 hours per day. A record must be kept indicating the date of birth, manual labor conditions for children, and the daily schedule, i.e., the assignment of hours of study, manual labor, rest, and meals. The record must be submitted to the labor inspector for visa, approval, observation, and warning at the end of each year. Article 181, no unemancipated child of either sex less than 18 years old can contract to work without the consent of his guardian. C. Women work. Article 182, in all enterprises covered by Article 1 of this law, women shall be entitled to a maternity leave of 90 days. After the maternity leave and during the first 2 months after returning to work, they are only expected to perform light work. The employer is prohibited from laying off women in labor during their maternity leave or at a date when the end of the notice period would fall during the maternity leave. Article 183, during the maternity leave as stipulated in the preceding article, women are entitled to half of their wage, including their perquisites, paid by the employer. Women fully reserve their rights to other benefits in kind, if any. Any collective agreement to the contrary shall be null and void. However, the wage benefits specified in the first paragraph of this article shall be granted only to women having a minimum of 1 year of uninterrupted service in the enterprise. Article 184, for 1 year from the date of child delivery. Mothers who breastfeed their children are entitled to 1 hour per day during working hours to breastfeed their children. This hour may be divided into 2 periods of 30 minutes each, one during the morning shift and the other during the afternoon shift. The exact time of breastfeeding is to be agreed between the mother and the employer. If there is no agreement, the period shall be at the midpoint of each work shift. Article 185, breaks for breastfeeding are separate from and shall not be deducted from normal breaks provided for in the labor law, in internal regulations of the establishment, in collective labor agreements, or in local custom for which other workers in the same category enjoy them. Article 186, managers of enterprises employing a minimum of 100 women or girls shall set up, within their establishments or nearby, a nursing room and a creche, daycare center. If the company is not able to set up a creche on its premises for children over 18 months of age, female workers can place their children in any creche and the charges shall be paid by the employer. Article 187, a Prakas, ministerial order, of the ministry in charge of labor shall determine the conditions for setting up hygienic environment and supervising these nursing rooms and creches.